first thing first, a motion for summary judgment. It looks like something like this. It's a court filing. Okay, I think you all have a copy. And what it does is it's asking the judge that, Judge, we don't need a trial. Okay, so we don't need a trial on this case at all because there's no issues of facts that are in dispute, which means neither side is disagreeing to the facts of the case. That's the basis of it. So a motion for summary judgment can happen usually after discovery closes. Sometimes it's filed before, depending on the circumstances. But so you go through the process where a lawsuit's filed, there's an answer filed, parties get involved in discovery, they exchange documents, information, questions, interrogatories, requests for permission, things like that. And then at a certain point, one party or both parties feel like there's nothing left in dispute, and it has to go to, and there's no reason for a trial. Okay, so the standard for motion for summary judgment, number one, is that no material issues or material facts in dispute. Okay? No material facts in dispute. Okay? Material meaning a fact that would be important to a judge making a decision in a case. A fact that would determine the outcome of a case. Not something that's irrelevant or meaningless, but a meaningful fact. Okay, so let's break this down into the most common type of case that everybody usually faces is a breach of contract lawsuit case, or it could be a debt collection case where you're getting sued for debt. But these all come down to breach of contract. It could be a lease, it could be a debt lawsuit, it could be a business litigation lawsuit, it could be any type of lawsuit that's based on a contract. So you have something called breach of contract. Okay, so the first thing is one party thinks that there's nothing left for trial. All the facts are in agreement. There's nothing in dispute, right? So that's when you file a motion for summary judgment. Okay. Now, what is the standard of it for a motion for summary judgment? The legal standard for MSJ. Okay, so the legal standard for motion for summary judgment says what? The judge has to decide what in a motion for summary judgment? Any ideas?
That there's evidence presented.
Well, the judge has to know, is there evidence on either side that rebuts anything, right? So let's break this down into something like a breach of contract case. So a breach of contract case generally has a couple of requirements. So when let's say breach of contract, the first requirement is what? For breach of contract cases have elements. You had to prove these things in a court of law. First things you had to prove is that there's a valid contract. Okay, for contract, okay? So is there a valid contract? Now let's say on an MSJ, you produce a copy of a contract that's signed by the parties, for example. Okay, well, is there a dispute as to the contract? Did you rent these premises from the landlord? And did you pay rent on these premises? Well, you have a contract, right? The next thing is whoever did the plaintiff, the landlord, the party suing the plaintiff, tender performance. Like, did they provide you premises? Did they, provide you the office space? Did they provide you the retail space? Did they, in a debt case, did they give you a line of credit, or did they give you a credit card that you could use? Were you able to access that credit line? Did they do their part of the contract? Yeah. And even if you don't have the original contract, they can get in bank statements and not bank statements, credit card statements, or proof that you paid rent if it's a rental case, things like that, because they can show that you also reciprocated back at some point to prove the existence of a contract, even if there's not one in writing. Okay. Third element of breach of contract is breach. Did the defendant, the party being sued and defending the case, breach the contract? Breach can be showed by, let's say, non-payment of your credit card bill. We didn't receive a payment after a certain date. That's breach, because you had a duty under the contract to pay back the amount of money you borrowed, right? If it's a breach of contract on a lease case, commercial lease, residential lease, they gave you premises. Did you pay your rent payment on time? No. Well, then, breach of contract is that you didn't pay your rent payment. Okay. And what's the last element of a breach of contract case? Yes. Did the plaintiff suffer an injury? Okay, question mark. Did they? Did the defendant breach the contract? So the question is, so to prove any case that any lawyer files for breach of contract or something similar, you have to show that there is a valid contract. The plaintiff, the party suing, did its duties under that contract, like either giving money, credit card limits, lines, whatever, provided premises for lease, like office space, retail, warehouse, residential, and the defendant didn't pay, and because the defendant didn't pay, the landlord or the plaintiff or the lender suffered an injury. Okay, so in a collection case, it would be, well, we didn't get our money back. This person owes us XYZ number of dollars, right? I don't know. So they can show, so those are what you need to prove to show an injury. Okay, so specifically the injury here in a lawsuit is that they're going to list a dollar amount for damages. Dollar amount, let's say $1,386 is what they list on the lawsuit. It could be 50, it could be $1.3 million, it could be 13 million, it could be $1 billion. Doesn't matter. It's still the same analysis. Okay. So you're thinking, okay, well, that's the breach of contract case. 4 elements. How does a court then determine if a motion for summary judgment is appropriate and that a trial will not happen? Because if a motion for summary judgment is granted, you will not have a trial. There's not going to be a trial in court. So how does one overcome a motion for summary judgment? Or how do you want, or if you're filing one, how do you prove? Or how do you get a motion for summary judgment granted by the judge in your case, right? So that's what we're going to discuss. That comes back down to the legal standard. So the legal standard for MSJ cases come out to what? So number one, is there any evidence at all to rebut or contest or dispute, any word you want to use, any of the elements of the claim? Which means, is there any evidence at all to rebut the existence of a contract? Is there any evidence at all to say the plaintiff didn't do their part of their promises in the contract? Is there any evidence at all that says the defendant did not breach the contract? Maybe it was the plaintiff that breached the contract. Maybe it was a third party that made it impossible for the defendant to perform the contract. Is there any evidence at all that shows that the plaintiff didn't suffer an injury or that didn't suffer this amount of an injury? Does that make sense? So we're looking for any evidence at all. And I want to highlight that. I want you guys to understand that it's any evidence at all. Okay? That's the first part of the legal standard. Okay? The second part of the legal standard for MSJ, motions for summary judgment, is not only is that the judge or court, right? The judge cannot weigh the evidence. Does that make sense? What do I mean by that? Well, let's pretend that there's a one of those scales, right? I don't know how to draw a scale, but I'll give it a shot. So there's a scale, has a thing that goes down like this, and has a thing here, and has a thing here, something like that. I don't know. Can't really draw a scale, but I think you get the idea. Okay. Let's say you have a scale. Okay. On this scale, let's say if the plaintiff is here and the defendant is here. Let's say if the defendant provides only one piece of evidence, and it's not about the validity of the contract, it's not about whether the plaintiff tendered performance. Let's say it's about, for example, this example. Let's say they say, well, I didn't breach it. The plaintiff actually sent me this email that says they're not going to do what they're supposed to do in the lease, and that happened first. They breached the contract. Let's say if you put that value at only £1, and let's say the plaintiff has a treasure trove of documents saying completely rebutting that one email or text message that the defendant has. And let's say you apply a value of £99 to what the plaintiff's evidence shows, and you apply a value of only £1 of weight to the defendant's evidence. The judge cannot weigh the evidence. So the judge cannot say, well, you have 99 pounds worth of evidence here, and you only have 1 pound of evidence towards only one part of your claim. So what's going to happen is that the motion for summary judgment will be denied to that element of the case. Okay? So let's say if you produce no evidence rebutting, as a defendant, you produce no evidence rebutting the validity of an existing contract. Well, that's granted by the court in the summary judgment. That 1 point is granted. You didn't provide any evidence that said the plaintiff didn't tender performance. Well, that element is proven. Doesn't need to have a trial on it. If you didn't provide any evidence that doesn't show that they're not entitled to $1,300, well, that is also proven. And now you're going to have a trial because this summary judgment will be granted in part. 3 things will be granted. Denied in part, meaning only that this piece is what's at issue, and there's going to be a trial over one thing only. The plaintiff doesn't have to prove this, or this at trial. They're going to get jury instruction saying that the judge is going to instruct the jury saying there is the existence of a valid contract. The plaintiff did tender performance, and the plaintiff did suffer $1,386 in damages. The instruction to the jury is going to go, or the judge is going to decide if it's not a jury case. Did the defendant breach the contract? That's the issue for trial. Okay? So the whole trial is going to have one issue, which is, did the defendant breach the contract? They're going to present their evidence, you're going to present your evidence, and the judge is going to make a determination based on the credibility of the evidence and the testimony. Or the jury is going to make that determination on the credibility of their evidence versus yours, the credibility of their witnesses and testimony versus yours. And that credibility determination is going to be made by the jury or judge. Any questions? Okay. So as long as you understand that either side, a plaintiff or a defendant, can both file for motion for summary judgment. And let's say if you didn't have any evidence at all on 1, 2, 3, and 4 to rebut their case, their motion for summary judgment must be granted by law. So what I want to talk about now is, well, if that's the case, how do we go about rebutting these things in typical breach of contract cases? Okay. What documents, what evidence can be used to rebut these things? So if you're getting sued and you're facing a motion for summary judgment against you, well, what do you need to get past to defeat the motion for summary judgment? And most common claims are breach of contract claims. So if we take a look at here at this particular one, so it reads like this. There's an introduction and there's a section for relevant facts. Plaintiff sued defendant to collect a debt on a credit card account. The debt arises from charges to purchase goods and services made by defendant, requested by a defendant using a credit card furnished by the plaintiff. In his motion for summary judgment, in brief in support, plaintiff offers the following evidence. The affidavit of plaintiff's representative regarding the account number attached to, and they provide their documents to show that there's an account, there's existing valid contract, there's account statement showing. So if you have a credit card statement, it proves the existence of a credit card account. It proves that they are giving you money as a credit card user. And then they're showing that there's no more payments made, so they're showing breach. And they're showing the final balance on that, so showing that, hey, this is the final balance of the account after you stop making payments, and this is what's in dispute. Okay, so as we go on to the next page, summary judgment standard. It reads here, summary judgment is proper when a movement, the party that moves or asks the court for summary judgment, establishes that there is no genuine issue of material fact and that it is entitled to judgment as a matter of law. What we said that is that you don't have any evidence to rebut any of these 4 points. Then they're entitled to judgment as a matter of law. Okay? In order to prevent summary judgment, the non-moving party must come forward with competent summary judgment evidence that creates a material issue of fact. Then it says all reasonable inferences and doubts are resolved in the non-moving party's favor. So for what that means is it's a big deal. What that means is if you produce any documentation at all, the judge has to look at it in the most favorable view to the party against who the summary judgment is sought. So if they're coming after you for summary judgment and you produce any document at all that can rebut any of these things, the judge has to take a look at that in the most favorable light to you. Okay? Even so, mere conclusions are not sufficient to raise a fact issue and do not preclude summary judgment. So conclusions are not enough. You need evidence. Texas Supreme Court encourages the use of summary judgment to avoid delays of trial when there is no genuine issue of material fact. Well, all states require like that policy. Then it goes into that plaintiff is entitled to summary judgment on its account stated claim, which is very similar to a claim for breach of contract. So transactions between the parties, indebtedness, an agreement, implied, promise, expressed, blah, blah, blah. Then it goes into plaintiff engaged in transactions that gave rise to the indebtedness. In a case to recover credit card debt in Texas, account statements that reflect charges and payments made by the defendants prove that the parties engaged in transactions that gave rise to the defendant's indebtedness to the plaintiff. Texas courts have overwhelmingly held that a plaintiff meets this element of his account stated claim by submitting proper business records affidavit of verifying the monthly account statements that reflect the defendant's charges, defendant's payments, and additional charges such as interest and fees. Plaintiff's summary judgment evidence easily establishes the requisite transaction between the parties as a matter of law that gave rise to the defendant's indebtedness to plaintiff, the attached business record affidavit and monthly statements, evidence that the defendant made charges and requested cash advances on the credit card and subsequently made payments toward the account balance. Moreover, periodic fees and interest charged on the account balance appeared on the monthly account statements. Thus, the plaintiff has established the first elements of his account stated, which is the existence of a contract and charges. Plaintiff and defendant impliedly agreed to a fixed amount due on the account, and defendant immediately impliedly promised to pay the indebtedness. Similar to the first element, plaintiff can prove an implied agreement between the parties as to a fixed amount due. The defendant implied promise to pay such an amount by submitting the monthly account statements verified in the business record affidavit. In a suit to recover credit card debt, courts routinely refer to an implied agreement between the parties as to the fixed amounts due on the contract and the series of transactions reflected in the account statements. Such an implied agreement can arise from the fact and conduct of the parties, monthly account statements for a credit card, blah, 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 blah. So they're talking about, you made payments on this account. You promised to pay. There's a balance showing. You owe them money. It just keeps going on and on and on. But the point of this is, then it says, in short, based on the series of transactions reflected on the account statements in Exhibit A and verified by the affidavit Exhibit 1, plaintiffs undisputedly established defendant implied they agreed that the amount due on the account on ending with 9005 is $22,283.63 and implied they promised to pay this amount. Therefore, plaintiffs entitled to summary judgment on the stated claim. Okay, let's break that down into simple English. So the plaintiff filed an MSJ. The bank filed, the credit card company filed a motion for summary judgment. In that motion for summary judgment, what documents or evidence are they using to establish the validity of a contract? If you understand, they did not produce a contract. Yeah, but what documents are they using to show that the bank transaction has so much? So credit card statements. The credit card statements. Now that is being used to show both that there was a contract and that the bank, the credit card company, lent money. Okay? What other documentation are they using to prove? Okay, a business record affidavit, and that business record affidavit just says that this is a real statement. So the business record affidavit is required to get past the hearsay objection. Okay, it's not required to prove your case, but it's required to show that this document, the credit card statement, is genuine and authentic. So it goes to the authenticity of the credit card statement, okay? Now, that's not the document so the business record affidavit doesn't actually prove this, 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 or this. It just goes to show that this document that's being used to prove these elements is authentic. Otherwise, if you don't have this document cannot be used in court because it falls under hearsay. The rules of evidence say that this is an out-of-court document to use to prove the truth of the matter asserted. That is, you have a contract and you owe money and you didn't pay money, and this is the amount that's past due on that claim. Okay?
The affidavit's just kind of like a sworn statement saying like this is true and correct, legitimate. Right.
Statement made and kept by the custodian of records for that business that created this document, and it is verified to be genuine and can get past the hearsay rule. Okay? Yes, by the custodian of records for, in this case, it's JP Morgan Chase Bank. Okay, so now you have this credit card statement. So when you have the credit card statement, it shows that there's a valid contract and lender lent money. What else does this credit card statement prove? Yeah? Payments made or not made. Breach. Does it prove amount that's left over at the end? If I give you your last credit card statement and you didn't pay it, and I give you the 2 or 3 months later, it's still showing no payments, does it show a final amount on the bill? Yes, show the balance. So it also proves this. See, the credit card statement itself proves the existence of a valid contract, the bank giving you money, you not paying it back, and then there being a final balance due at the end. So they're literally using one document which proves all 4 of their claims. That's all, and that's enough. Does this sound unwinnable? It sounds hard to beat, right? On the surface it does, yes. But now let's talk about how you turn that around a little bit, okay? Now you understand, I'm going to take this business record affidavit part off. Because that's not really a document that's being used. But if let's say you are in a case and the bank doesn't provide a business record affidavit, what do? You stand up, you say objection, hearsay. That's it. Judge says, what do you mean? You say, well, judge, that document is hearsay. It can't be brought into court to prove the validity of the contract, the plaintiff's tendering to performance, the breach of the contract, or that the defendant suffered an injury because it's not authenticated. Authentication is required, otherwise this is hearsay.
When
Okay.
you're looking at trial, like you'll have like everybody's evidence, right? So you'll have known by that point that it's missing, so you'll be prepared to make that
Yes,
statement. Yeah.
because you know if they have a business record affidavit or not. If they don't, you object to the admissibility of the document as hearsay. And the judge should deny that document from being introduced. Now, let's say you get a trial and the opposing attorney doesn't have a business record affidavit. And you stand up and you say, objection, hearsay. That document is hearsay. It can't be brought in to prove any of their claims because I don't see a business record affidavit. Now, how else could they get that document in if they don't have a business record affidavit that day at trial? Witness, but not just any witness. The witness must be competent and must be a custodian of records with knowledge of this particular document and must have been working there at the time that this document was created. So either you can get this in either with the business record affidavit or with a competent witness. But when you get there, you'll see, if you go to trial, you see there's never really a witness there for the bank. They should have this. If they don't have this, and they don't get this document introduced, and you win that hearsay objection, what happens to the case? No, you're at trial. The opposing attorney stood up and says, Judge, this is the document. This shows this objection. Hearsay. Judge agrees with you. What happens? Document gets thrown out. Then what happens? There's no case. You won. It's dismissed.
What if like they were to bring the contract in for a trial? Would there be a way for them to do that? Have that like supersede the business record
No.
affidavit or the witness?
No, there's only two ways to get it in. That's the only two ways to get it in.
The contract itself.
The contract itself cannot be brought in unless you have a business record affidavit, or you have a, well, they don't. First of all, credit card companies never have a contract. There's no contract. They try to bring in the credit card statements. That's it. Okay. Now let's assume they do have a business record affidavit. Let's make it a little bit harder. They have a BRA, business record affidavit. Okay. Now let's say pretend to be the defense. Here, the delta is symbol for defendant. Okay. Now the defendant can respond in writing, and you're supposed to respond in writing to a motion for summary judgment. Now, let's say if that you don't see a business record affidavit in the motion for summary judgment. How does one go about attacking that element on an MSJ? Yeah. You'll say it's hearsay. You'll say it's hearsay. Talking about whatever document that they're using for the first element, right? What else can you say? It's not authenticated, which also means that it's hearsay. Okay. Let's say in a case where you have a real dispute over the validity of a contract, like I don't remember signing this, or I didn't sign this contract at all. What do? How can you get that in to rebut the validity or existence of a contract? Come on. What else? An affidavit from the defendant. A sworn affidavit, a sworn statement. From the defendant saying so. I didn't sign a contract. There is no contract. I don't know what the heck this piece of paper is. Well, then so if that happens, it's going to trial. You understand? Any evidence standard. It doesn't matter how strong or weak it is, as long as it's evidence. A sworn statement from the defendant contesting the existence of a contract or the validity of a contract is evidence.
Would the opposing party like ever dig into a sworn statement and like
Yes,
see
at trial. They will, at trial. If they will. Of course they will. You signed this sworn statement, yet you lied. You lied because this document shows this. They're going to impeach the witness's credibility at trial. So don't lie. Don't make sworn statements under penalty of perjury. So I'm not telling anyone to lie. I'm just telling you that what defeats these elements, right? So that would defeat it. Then you would have a trial with a judge or jury, okay? But let's say if it's true and you didn't sign a contract, you're supposed to sign a sworn statement saying, I didn't sign a contract. But if you did, don't do that. Okay. Disclaimer. Okay. Number 2. Let's say you have a dispute about the tendering of performance. Okay, this generally happens in like things like construction breach of contract cases. I hired a contractor. That contractor sent me this huge bill. They didn't even do what they're supposed to do. I wanted to install a concrete patio in my backyard, for example. And they never showed up. They never did their part of the job. I don't have a concrete patio, yet he's suing me for the whole amount. Well, what do you think in that particular situation would be useful? Photographs, recordings, witnesses, other witnesses, an affidavit from the defendant saying that. Because then that attacks, you didn't even do what you were supposed to do, and yet you're suing me. How dare you? Right? But in a credit card case, how would you say, I never received the benefit of this credit card? Let's say it was an identity theft case, for example. Someone is a victim of identity theft. I never opened the credit card. Somebody opened my information. Now I'm getting sued for it. We handle ID theft cases, right? This is a legitimate thing in this day and age. You have victims of identity theft, and they get credit cards opened in their names, and somebody else is using them. Well, obviously, they can show that this credit card statement was, had charges and the bank tendered performance and da-da-da-da. That's what they're trying to show. How do you rebut that, guys? Affidavit, an FTC report, a police report. So you can rebut tendering performance by saying, it wasn't even mine. I didn't even get it. Look at the address on the credit card statement. It's not even my address. I never lived in Waxahachie, wherever the heck that is. Okay. So you can show things like a police report if you're a victim of identity theft. If you don't have one of those, you can go online and get an FTC affidavit, FTC report for identity theft. You can get, what else? If you're a victim of ID theft. What else can you do? Sworn statement. An affidavit saying I never received benefit of these services. Okay. Now we have another case where somebody worked for an employer and then they forced her out because of toxic work conditions. She was there for 47 out of 52 weeks. Okay. How does she show that she tendered her performance? I worked there for 47 weeks. So you can't get 52 weeks worth of damages from me. You can, maybe if you get it, you can only get 47. I mean, sorry, 5 weeks because I worked 47 weeks. Yeah, so it's 5 weeks left, right? So you shouldn't sue me for all the money. Let's say you gave me money to relocate. It was like 30 grand or 20 grand or whatever it was, and all these benefits for me to join, and I joined, and I worked there for 47 out of the 52 weeks. So you benefited from 47 weeks of my work. It's not like you had zero and I took 30 grand and I took off. If anything, I might owe for those 5 weeks. But so you can show that they stopped tendering performance because they created a hostile work environment. How do we show that? that the plaintiff created the hostile working environment. The plaintiff didn't tender their part of the deal. Text messages, HR incident reports, emails, sworn statement from the defendant. You understand? Okay. So many ways. Credit card cases. Usually, that's going to be hard to show that you didn't receive stuff unless, and there's because there's a credit card statement showing that, and there's a business record affidavit. They're going to get that in. They're going to get that in. Then it's like, well, did you breach? Yeah, I stopped paying. Okay. Well, what if it was a different type of case? Well, did you stop paying, or the other party caused the breach? It could be the other party caused the breach. The same documents can be used to show element 3. Like, for example, in the hiring case, where she leaves before the whole 1-year term is up. You forced me out. You forced me out because you created a hostile work environment. It was difficult. I couldn't deal with the stress, tension, and whatever you created. There was drama, extreme amount of drama going on there. Well, that means you created the conditions to force me out of this job. So a lot of times people don't fire people. What they do is they create they demote somebody. They'll dump a lot of work on them. They'll give them a pay cut. They'll cut their benefits. They'll do something, and then the management will make their life a living hell, and just harass them, say mean things or whatever. Just kind of pile work on them unnecessarily, and then they're hoping this person just quits on their own so that they can say, well, you left and you quit, and we didn't fire you, and it's not retaliation. You left on your own. That happens. So depending on the type of case it is, if it's a credit card case, did the defendant breach the contract? Well, how would you rebut that in a credit card lawsuit case? If it's identity theft, it's the same stuff here. It goes to 3 as well. If it's ID theft, or if maybe there's disputes on the balances. Maybe you filed a series of disputes saying, hey, I had these unauthorized charges on my credit card bill, and I told you, I called American Express or Capital One or whoever, and I said, I want you to get rid of the unauthorized charges that showed up on here. Otherwise, I'm not going to be able to pay my bill. And you did an investigation and you didn't do it properly, and now I couldn't afford the bill or whatever because my minimum payments went up or whatever happened. That could be a situation. Now, the other thing is, what about the defendants? This is the main part in credit card defense cases where you can actually get these things handled. So the main thing is number 4. Did the defendant suffer an injury in this amount? Okay. Well, you can say in an affidavit, for example, that you have an injury. Sure. Let's say there's a BRA. Let's say you concede the existence of a contract. I received money in the contract, and I didn't pay. And I do owe you money. I just don't owe you that. That amount is wrong. Now you're going to have a trial. The trial isn't going to be about liability anymore. It's not going to be about the existence of a contract or whether you owe money or whether you caused the breach. It's going to be about, well, is the amount right? Right? So now you're going to have a trial, but it's going to be like, well, I don't owe $1,300, Judge. I had a couple of payments that I made that they didn't credit. Or I had a couple of these things I disputed, and I was supposed to get those back on my balance was supposed to go down because I disputed a couple of charges. And so, I had a $1,300 charge that came in. And I was like, this isn't mine. I disputed it. And what happened was they completed the investigation and they said, no, we don't believe you. But it's not my charge, Judge or jury. Well, in that case, you can have a trial on whether or not you owe $1,386.
Like with the Hartley case with the 47 weeks and maybe paying back the balance of that, like in her situation,
Don't say names of clients. Okay, you go ahead.
and so in a situation like that, there was some evidence where she had actually brought value to. Would there be a way to like offset that by saying like, well, I actually increased their revenues with my performance?
Maybe, but I think the better angle on a case like that would be to show that the company conducted the breach by creating a toxic workplace
Okay,
or work environment.
okay.
And that's what, and also the other angle would be that they didn't suffer 10 grand or whatever, 6 grand in damages because I worked 47 out of the 52 weeks. If you adjust it, so divide the total number by 52, multiply back by 5, that's your entire amount you may have suffered at most. So you take, let's say if they're saying, well, you owe $5,200. Okay, let's suppose. Divide that by magic number of 52 weeks in a year. Amazingly, we're down to $100 a week. Man, I'm good at math. Then you multiply that by, well, I worked 47 out of the 52 weeks. That means I didn't work 5 weeks. So if anything, if I owe anything at all, it should be capped at $500 because you did receive 47 out of the 52 weeks of my performance back on the contract. So this amount is incorrect, and I should only, if I'm found liable, it should only be for $500. But I shouldn't be liable for the 500 because they caused the breach to begin with, not me. I didn't do it; they did.
So so you can sort of play with that total a little bit.
You should play with that total as much as you can. And so now, how do you prove that? Sworn statement, affidavit. That's great. What else? You can, the time frames you've worked. So paychecks, pay stubs, showing first date and last date, or just your last pay stub showing when you quit. There's a contract that shows what the term of her employment was supposed to be for 1 year, and you can show the last pay stub that shows when you stopped working there. That proves that this amount is not right. Text messages, emails, and sworn statements show that the defendant breached that the plaintiff breached, not the defendant in that case. Now, when you set these things up and you fire back with anything that is even, they say the word I think in law is even an iota of evidence, a summary judgment must be denied. Okay? Any questions about this? Good? Okay. Hit pause on that one.